I want to welcome you. I'm Sylvia Martin-Laforge. I'm the Director General of the Quebec Community Groups Network, and I'm very pleased to be here today. This 3-day event is terrific, and it's indicative of the interest that people have for such an event. And it is the Committee of Concordia University English-Speaking Communities Research Network, QUESCREN. So thank you, QUESCREN, for doing such a good job. I'd like to acknowledge the funding of the provincial government, the Secretariat for English Language Relations. And this title of this session is 5B, Education Rights and the Law. Now, the speakers. I know both of these speakers very, very well, and I always appreciate hearing them. I hear them sometimes on chats just between us, but now today they are going to bring their ideas and thoughts to all of you. Marion Sandilands was born in Montreal and is a graduate of McDonald-Kelsey High School in St. Hubert. Now it's called Heritage High School. She completed her undergraduate and law degrees at McGill University. She now practices law at Conway Litigation in Ottawa, practicing civil litigation, constitutional and administrative law. Marion has appeared before the Supreme Court of Canada on matters of constitutional law and teaches Canadian federalism law at the University of Ottawa. And for those of you who have come to some of our QCGN events, you know that Marion is our constitutional lawyer on matters of Bill 96. Richard Bourhis obtained a BSc at McGill University and a PhD in psychology at the University of Bristol, England. He taught at McMaster University and is emeritus professor in psychology at UQAM. He published in English and French on topics such as discrimination, intergroup relations, immigration, communication, and language planning. He is Fellow of the Royal Society of Canada and received the Gold Medal Award of Canadian Psychology Association for his lifetime contribution to Canadian psychology. And as I said, both of these individuals are on my speed dial, and I'm looking forward to hearing them today. So, Richard is going first, and I look forward to this, Richard. Thank you.
Good afternoon. On the planned decline of English education in Quebec, Bill 96 and some ideological clarifications. Today, I will highlight the decline of the demographic and institutional vitality of the Anglophone minority with a focus on education. Then I propose 5 ideological clarifications which challenge the Anglophone minority of Quebec. Just 2 little slides on demolinguistics. In blue here on this slide, you have the percentage of Francophones that are mother tongue speakers of French in Quebec society. In 1971, before Bill 101, there was 80.7% Francophones in Quebec. By 2016, there was 77% Francophones in Quebec. Then, of course, in red are Quebec Anglophones mother tongue, 13% in 1971 before Bill 101, 7.5% in 2016. Then in black, you will see the allophone percentage in the province. From these are people who have neither French nor English as a mother tongue. They could have Mandarin or Arab or Spanish. 6.3% in 1971, and now 13.2% in 2016. So that's the ratio of the 3 groups we're dealing with today. Then we look at how many are bilingual amongst the Anglophone population. You can see in red here that the number of French-English bilinguals amongst English mother tongue speakers rose from 37% in 71 all the way up to 69% in 2016. Amongst allophone, it went up from 33% to 51%. And amongst Francophones, it went up from 25% to 40%. So we have here quite a lot of people that are bilingual in the province. Then we look at a few of the language laws eroding access to English schools in Quebec. Up to the 1960s, as you all know, Francophone, Anglophone, allophones, and immigrants had freedom of choice to then attend English or French public schools. In 1977, the Parti Québécois adopted Bill 101, banning Francophone majority and immigrants from attending English schools at primary and secondary level. Bill 101 stipulated that Anglophone pupils could attend English schools only if one sibling or parent had spent most of its primary schooling in English within Canada, what is known as English eligible students. How did Bill 101 affect the size of the English school system? Well, in 1971, there was 256,000 students in English primary and secondary schools, our 100% baseline. By 2018, there were only 96,000 students left in the English school system, representing only 37% of its original size in 1971. This is the largest drop in an English language school system in Canada. By 2018, 87% of allophone students had shifted from English to French schools. So Bill 101 succeeded in banning allophone, francophone access to English school system. On May 13, 2021, the CAQ Québécois government tabled Bill 96. Bill 96 freezes the size of the 5 English CEGEPS. Note that post-secondary education is not protected by Article 23 of the 1982 Canadian Charter. Bill 96 will cap the growth of those 5 English CEGEPS to 8.7% per year until 2029. Prime Minister Legault said, Bill 96 is clear. Anglophones represent 8% of Quebec, and they will get 8% of the new spots in the future. Bill 96 gives priority access to English CEGEPS for English eligible students. As we said, those having one parent who attended mostly English schooling anywhere in Canada. As we know, this English eligible criteria is too narrow to allow all English speaking students to gain entry in English CEGEPS. Then in June 18, the CAQ Minister McCann froze the size of English CEGEPS for 10 years. Now, the CAQ Minister freezes this enrollment in the 5 English CEGEPS to the 2019 level of 26,945 places across Quebec until 2029. No growth at all is allowed. This freeze is designed to reduce the size of the 5 English CEGEPS from 17% of all the places in 2019 to only 13.4% in 2029. We think that this decree will supplant Bill 96, capping 8.7% of the annual growth of the English CEGEPS. What's important also is that 43 Francophone CEGEPS are provided with an extra 21,000 places, growing the French network from 131,000 to 174,000 places in the Quebec system. McCann said the following in French. En vertu du projet de loi 96, les membres de la minorité historique anglophone auront priorité au moment de l'admission dans un cégep où l'on enseigne la langue de Shakespeare. What does Minister McCann mean by Anglophone historical community? Prime Minister Legault said they are people who are eligible for English schooling in Quebec. It's defined in Bill 101. It's people who learned English or went to English school in Canada. He agreed that a person born in another country whose mother tongue is English will not be eligible for education and healthcare in English. Quebec government restrictions on access to English primary and secondary schools and the freeze on the size of the 5 English CEGEPS require Anglophones and Allophones to reconsider the prospects of linguistic minorities in Quebec. Here are 5 ideological clarifications worth considering. 1, Anglophones and Allophone minorities who stayed in Quebec have proven that they accept the imperative of maintaining the status and use of French, and the majority of Anglophones have become bilingual. The English-speaking communities of Quebec are not responsible for the substantial status and spread of the English language in the world, including in Canada and Quebec. French in Quebec will always be a minority language relative to English and Spanish in North America. Eroding the status of institutional vitality of the English-speaking minority will never be sufficient to neutralize the international drawing power of the English language for Francophones and Allophones in the province. Our second ideological clarification, Québécois Francophone national discourse invokes threat to the French language and identity from the presence of the English language and immigrants of different linguistic, ethnic, and religious background in Quebec. Québécois Francophone discourse invokes this threat to the French language as justification to erode the institutional vitality of the English-speaking communities of Quebec. Quebec government laws reducing access to English schools and CEGEPS illustrate how the Francophone majority can use its minority status at the Canadian and USA level to justify eroding the English educational system at the provincial level. Third, Quebec laws restricting access to minority English schools and CEGEPS are legitimized rhetorically by invoking that Québécois Francophones are a fragile majority in the province when considered in the North American setting. Can a formerly subordinated majority, such as Québécois Francophones, accept that it has gained linguistic, institutional, and economic dominance within its own territory of Quebec? Can Québécois Francophones accept a paradigm shift by reframing their status position from a fragile majority to that of a dominant majority? Québécois Francophones are a dominant majority imbued with the psychology of a besieged minority, armed with all the tools of the Quebec state. Fourth, can Québécois Francophone dominant majority develop the cultural security to view its own linguistic minorities as a responsibility rather than threatening liabilities? Can Québécois Francophones reframe Anglophone and Allophone minorities as assets contributing to economic and cultural development of Quebec? Such reframing will make young Anglophones and Allophones feel more accepted in Quebec society. Québécois Francophones acting as a secure dominant majority could view investment in the institutional vitality of its linguistic minorities as building social cohesion and enhancing the adaptability of Quebecois society within North American economy. And lastly, Anglophone, Allophone minorities have the right to consider Quebec as their homeland as much as do the Francophone dominant majority. All pay taxes. Quebec Anglophones and Allophones built many of their own institutions since the 20th and 19th century. They have the collective right to protect and develop their language, cultures, and institutions. This without being stigmatized as traitors to the Quebecois French dominant majority. Leaders of the English-speaking communities of Quebec have the right to develop the organizations they need to promote the defense and development of their institutional vitality in education, healthcare, social services, the judiciary, municipalities, economy, etc. Quebec Anglophones and Allophone minorities are as much part of la nation québécoise as are all the Francophone dominant majority. All have equal rights and duties as citizens of Quebec. Quebec Anglophones, Allophone minorities, along with Francophone majority, have the right to endorse multiple national, cultural, and linguistic identities, including to Quebec and to Canada, without stigma or exclusion. Merci. Thank you very much.
Michelle, that was terrific. So Marion.
Good afternoon, everyone. I come to you today from Ottawa, the traditional unceded territory of the Algonquin Anishinaabe people. I want to say two things before I dive into my presentation. First thing, as Sylvia alluded to, I do practice in this area of law, and I do have clients in the English-speaking community of Quebec. Today, I'm here in my own personal capacity, and the views I express are my own. That being said, second thing, I roundly denounce the comments and attitudes displayed yesterday by Michael Rousseau, CEO of Air Canada. They offend my values, my personal values as someone born and raised in Quebec and as an advocate for the English-speaking community in Quebec. And I encourage the English-speaking community of Quebec to denounce as well. Now, diving into my presentation, we decided I should go after Dr. Bourhis today. The picture he paints is rather bleak. And so my presentation is meant to be a little bit less bleak. Dr. Bourhis' remarks today are about the planned decline of the English language school system. And today I'll kind of talk about the other side of that, which is Section 23 of the Canadian Charter as what I'll characterize as the constitutional foundation or the bulwark for that English school system. So today we'll explore what kind of constitutional foundation is this, and what limits or obligations does it place on the province with respect to English language education. That's what I'm going to try to do. So this is the 4 topics I'm going to cover. What is Section 23 of the Charter? Some of you may be super familiar, this may be the first time you're learning about it. I'll talk about a little bit of the history of Section 23 and its importance in Quebec. Third, I'll talk about some recent developments about what's going on with Section 23 outside Quebec. And then fourth, I'll bring us back into Quebec and talk about some very recent happenings that are happening right now in the province and how this provision is continuing to serve as a really important foundation for education. So first, what is Section 23 of the Charter? First, what's its purpose? Second, what does it guarantee? And third, why does any of this matter? So first, what is the purpose? I'd love to spend a lot of time tracing the history, but we don't have the time. But suffice to say, our 1867 Constitution included protection for minority denominational schools, so Protestant and Catholic. And in Quebec, that would have been the Protestant schools would have been the minority. And that somewhat overlaps with language, particularly in Quebec, but never completely. Whereas Section 23 is part of the Canadian Charter of Rights and Freedoms, which came in 1982. And it's a new layer, and it directly protects the language of education. So there's been a shift, particularly in Quebec, but pretty much, well, in most provinces, away from denominational and towards linguistic school systems. So that's how Section 23 protects the language of education. The purpose, as the Supreme Court has said, the purpose is to preserve and promote the language and culture of official language minorities. So that's English-speaking community in Quebec, and that's Francophones outside of Quebec. And that includes a concept of protecting community vitality. Section 23 has been called the linchpin of Canada's commitment to bilingualism. Why? Because it's about educating the next generation of the linguistic minority. The Supreme Court has said it's the heart of the language protections in the Charter. And on my little slide here, I've highlighted all the language protections in the Charter. It's like a third of the text of the Canadian Charter is language rights. And I wish people talked more about them. But anyway, Section 23 is said to be the linchpin of all of those. And the way it frames English-speaking Quebec as a minority alongside Francophones outside Quebec means that the law, as of Section 23, as the law evolves, it will affect both of those linguistic minorities. So that's why we should always be paying attention to what's happening with Francophones outside Quebec. Next, what does Section 23 guarantee? 3 things: eligibility, quality, and management and control. First, eligibility. I'm not going to take us through the technicalities here, but this is what the Charter guarantees in Quebec, 2 categories. And if you read them and if you study them, you realize that they track almost exactly what the Charter of the French language says. And that's no accident. So, but do always remember that the Canadian Charter, Section 23, provides the constitutional floor, whereas Bill 101 kind of provides the ceiling. Nobody except these people are permitted to attend. That's what Bill 101 says, with exceptions. Section 23 of the Charter says every province must guarantee at least that these people can attend. doesn't prevent provinces from allowing more. And what's happening in Quebec is that Bill 101 sets the ceiling, Section 23 sets the floor, and actually the floor meets the ceiling in Section 72 and 73 of Bill 101. That's how it works. But remember that Section 23 is the constitutional floor. So these categories, the ones that the Premier says, this is the historical Anglophone community. So these categories, as Dr. Bourhis mentioned, they come out of Bill 101 from the 1970s, and then they've been negotiated into the charter here in 1982. Was this ever understood to be trying to freeze some kind of historical community in time? I don't think so. It's really just the special compromise that was struck in Section 23 of the charter. So much has been made of these categories that doesn't quite align with their origin. Next, what does Section 23 guarantee? It guarantees a quality, a certain quality of minority education. So the idea is Section 23 guarantees, I'll just go back, these two categories of people for their ability to send their children to school in the minority language out of public funds. Province must fund the school system. And here we're back to quality. The province must fund a certain level of facilities and a certain quality of those facilities. So what must they fund in terms of facilities? In separate school, shared school, school board, what kind of facilities must be funded? That's determined on a sliding scale depending on the numbers. And there's a whole new body of case law on how to figure that out. But also those facilities and the education experience must be of a certain quality. The Supreme Court has set a very high standard. It must be of substantive equivalence. The Supreme Court has said official language minorities are entitled to have their children receive anywhere in Canada an educational experience that is substantively equivalent to the experience provided to majority language children. This is a very recent decision of the Supreme Court of Canada. This part of Section 23 is really all about money. It's about the obligation for the province to set up and fund minority language facilities of a certain quality. And it's a very generous framework that the Supreme Court has set out quite recently. It creates an obligation on provinces. Third, what else is guaranteed under Section 23 of the Charter? Management and control. This is a big one in Quebec these days. This is a Supreme Court decision from 1990 that says the minority language group should have, quote, a measure of management and control over the educational facilities in which their children are taught. And they must have management and control over those aspects of education which pertain to or have an effect upon their language and culture. I actually set out a list, in addition to this general principle, a list of things that the minority language community is supposed to have exclusive management and control over. Why is management and control important? What does it have to do with Section 23 and its purpose? Well, the Supreme Court has said this very tactfully. Provinces, in their wisdom, don't always act with their linguistic minorities in mind. And big shocker, this is not simply the case in Quebec. This is the case in most provinces. Varying degrees of apathy and hostility towards minority language communities in most provinces. And I will quote from what the Supreme Court says, quote, as the historical context in which Section 23 was enacted suggests, 1982, minority language groups cannot always rely on the majority to take account of all their linguistic and cultural concerns. Such neglect is not always intentional, and they go on. They're being charitable. So that they understand the politics of why management and control is important to a minority language education situation. Finally, why does this matter? Well, two things. The Charter of Rights and Freedoms is the supreme law of Canada. So it prevails over any provincial statute that is found to not comply with the basic obligations of the Charter. So that's why through the years, there have been several challenges brought to the Charter of the French language under Section 23, say they violate the guarantees of Section 23. And also, very important these days, Section 23 is one of the provisions of the Canadian Charter that cannot be overridden by the notwithstanding clause. So we hear a lot about the notwithstanding clause and how it's overriding, all of the possible charter rights. Well, Section 23 simply cannot be overridden. And that's been important in the past, and it's again becoming very important. So that's why I say Section 23 is the constitutional foundation for the English language system in Quebec. I won't put names on the characters in this cartoon. I'll let you think of that. Next, the history of Section 23 in English-speaking Quebec. I'm going to go through, 44 decades in 2 minutes. Just to say, as a general proposition, up until quite recently, Section 23 in Quebec has been really all about that eligibility problem, those restrictions in the Charter of the French language on who can attend English school, and attempts to push back on those restrictions based on the Charter guaranteed categories. So the very, very first constitutional challenge that was brought under Section 23 was from Quebec. It was Quebec Protestant School Boards. It was apparently filed weeks after the Charter came into effect. And remember, the notwithstanding clause had been invoked on all of Quebec legislation, but they couldn't invoke it for they couldn't override Section 23. So there was a challenge immediately brought. This had to do with an old provision in the Charter, in the Charter of the French language that was even more limiting than the current one, the so-called Quebec clause. And that was struck down at every level because it plainly violated Section 23. So that was an early victory for the English-speaking school system. And I don't have time to get into the details, but just to say, I love the 1984 case. It was the first case that the Supreme Court dealt with in Section 23. It sets the tone. The Supreme Court has consistently taken a very broad and propositive approach to Section 23, and this was the first one. And then below here, there are the 3 other cases that were brought from Quebec, Gosselin, Solski, and Nguyen, and I'm not going to have time to talk about them, but I'll say that they're all about the eligibility restrictions. Now I want to talk about what's going on outside Quebec, because as I say, as the law unfolds and advocacy is happening outside Quebec, that is going to have an effect on what law applies inside Quebec. So it's very interesting to see what's happening outside Quebec. I'll do four things. First of all, in Nova Scotia, this is a bit of old news, but in 2018, Nova Scotia, the province abolished all of its school boards. And this is a trend that's been attempted in several places. Manitoba tried and then pulled back, I think. But Nova Scotia did it. But when they completely wrote a whole new law for their new school administration, but they completely exempted the Francophone school board from the new regime. So they left the Francophone school board completely intact and status quo because of their obligations to respect the right to management and control under Section 23 of the Charter. So status quo for the Francophone school board, and I believe still is. And guess what? There is no litigation happening in Nova Scotia over this issue. Second, British Columbia. This one was well publicized. In 2020, the Supreme Court released its latest decision on Section 23, and it was the culmination of a massive litigation undertaking in British Columbia. It was the Francophone School Board and the Francophone Parents Association making multiple claims for new school construction and updating facilities for the entire Francophone School Board in British Columbia. They had mixed results at the courts below, but they had a really strong victory at the Supreme Court of Canada. The Supreme Court set out a very generous framework, as I was describing before, about the facilities and the quality of education that's mandated under Section 23. And this is good news for every single linguistic minority across Canada. And the real question in British Columbia right now is, will the province actually implement what they've been mandated to do here? The Supreme Court didn't actually order the province to build facilities. They just issued a series of declarations of violations of Section 23 and left it to the province to implement. Will they implement? I haven't heard overwhelmingly good things coming out of British Columbia on that front. Northwest Territories, this is brand new. You may be surprised to learn Quebec is not the only province that limits eligibility for minority language schools. A number of other provinces and territories have very stringent limits on eligibility, and they use Section 23 as the floor, and they try to kind of limit it to only people who have the constitutional right. And Northwest Territories is one of those places. And there's a litigation coming up right now. In Northwest Territories, they limit eligibility to rights holders, plus there's a small limited discretion that the school board can exercise to admit additional people, but that discretion must also be approved by the minister. And this is the case where the school board wanted to admit some non-rights holders, and the minister kiboshed it and said, no, I'm not going to allow this. And that was brought to judicial review at the court, and actually they won. And then just recently that was overturned at the Court of Appeal of Northwest Territories. And then leave to appeal has just been filed at the Supreme Court. So watch this one. If this one goes to the Supreme Court, that will be the next Section 23 case. And apparently there's also an argument being made that the Court of Appeal couldn't understand the submissions that were being made in French in the minority language, and that was an additional possibly constitutional violation. So something to watch as it goes up, if it goes to the Supreme Court. So they've filed for leave, and if the Supreme Court grants leave, then it will be heard at the Supreme Court. That will happen within a year or two. And finally, Alberta, litigation happening in Alberta. Alberta in 2020 announced it was going to close Campus Saint-Jean, which is one of the, I think possibly the only, or one of the only post-secondary education institutions in French in Alberta. It's sort of attached to the University of Alberta. And this was roundly resisted by the Francophone community, not only in Alberta, but nationwide. And in August 2020, the Association Canadienne Française de l'Alberta launched a judicial review. And one of the bases of the judicial review is Section 23 of the Charter. And it's a very interesting and novel argument because they're saying Section 23 of the Charter requires the province to fund post-secondary education, because that's the training of teachers that will provide education in the primary and secondary education system. This is a new frontier for Section 23. It's currently being argued before the courts right now. Watch how that develops as well. Does Section 23 apply in post-secondary? If it does, that has knock-on effects in Quebec, because we're seeing new restrictions on post-secondary education in English in Quebec coming in right now. So I'll take us back to Quebec, and Sylvia hasn't stopped me yet. So I'll go as, I'll try to be brief. 2 minutes?
Well, yes, you haven't been watching the chat, but please, yes.
I haven't been watching.
Here, I'll give you 2 minutes.
Oh, okay, okay. I'll do 2 minutes, and then I can take questions.
Yes.
In Quebec, Section 23 is heating up again in a way that hasn't happened since 2009. It was all quiet on the Western Front until 2019. So we have two things, the abolition of school boards in Quebec, and we have Bill 21, and both of those have invoked Section 23 back into the game. So Bill 40, I'm sure anyone who works in the education system doesn't need to be told what this is about, or what the problems are with it. And that there has been a litigation that has been started by the Quebec English School Boards Association, and all 9 school boards, I believe, are parties to that. So governments tried to abolish school boards and very severely diminish school community governance of education, and that's being resisted by the school board leadership. There's a stay in place right now. The trial was just happened in the spring of 2021, so there should be a decision coming anytime. Will it be appealed? Will it go up to the Supreme Court? How long will this uncertainty last? Don't know, but it's 100% based on the right to management and control under Section 23. So that's going to be very important coming down anytime. What's at stake? I think control by the English-speaking community over its education system. The loss of control has been gradual over years and decades, but Bill 40 was kind of really the last straw. And finally, Bill 21, which was passed in 2019. How do we get to Section 23 here? Well, there were multiple constitutional challenges to Bill 21, but it was protected by the notwithstanding clause. So many of those constitutional challenges had to find ways to get around that problem. Well, Section 23 is not subject to the notwithstanding clause. Can Section 23 protect the English school board system from Bill 21 applying? Well, the EMSB argued that it could. They said the school board should have control over hiring of staff, and Bill 21 puts a limit on their ability to control their hiring of staff, which is true. They can't hire certain types of staff now. And also they said Section 23 protects management and control of the culture within the English school boards. And Bill 21 infringes on that. It interferes with the cultural setting of English school boards. I like to point out that there's no comparison here made between English school boards and French school boards. That's not how it's framed. And I would, if someone wants to ask about it, I'll talk about it further. It's not an us and them argument. Anyway, the trial judge accepted this argument. And in fact, this was one of the only arguments that was accepted to strike down parts of Bill 21. However, since the province appealed this, it's status quo in the English school board until the thing is finally determined, or until the court makes some kind of provisional order. And the appeal is happening right now, and I'll probably say I'm counsel for the Quebec English School Boards Association on the appeal. They're intervening on the appeal. So I'm following this very closely. So anyway, both of these cases are ongoing. They're really going to test, oh, I have a final thing. They're really going to test how firm is this foundation of Section 23. Is it the house made of brick, or is it the house of straw? And here we go. I can also answer questions about Bill 96 if they're party. Thanks.
Thanks, Marion. There are a couple of questions right now in the chat. One that is connected to your piece particularly is a question from Cindy. Who determines the equivalence of the educational quality of the minority language? From a legal perspective, would curriculum development fall within management and control provision of Section 23?
Oh, excellent questions. Okay, so the first one was
yes, Cindy.
From whose perspective, I get way too excited about this stuff. From whose perspective, the Supreme Court has set out the test is from the parent's perspective. Would the reasonable parent view this? So the reasonable parent considering whether to send their kid to the minority school or the majority school, would they consider the educational experience be equivalent if they sent their kid to the minority school? So you're thinking about not, the facilities that are offered, extracurricular activities, the type of curriculum, like all of that factors into whether there's substantive equivalence between minority and majority schools. It's a hard nut to crack because of course the contexts are often different. Minority schools often are just smaller than the majority schools and they can't offer the same range of things. So how is that to be factored in? That's harder to ascertain, but it is supposed to be the perspective of the parent that's taken into account. And ultimately the court decides what they think the perspective of the parent is. But for parent. Second one, does curriculum development fall under management and control? If I were to put up that list of things that the Supreme Court said should be under the control of the minority community, curriculum would be on that list. Yes, the minority community is supposed to have control and management over curriculum development.
Thank you, Marion. I'm going to go back up to the first question from Brian Rock, but I see a very good question from Chris Bourne as well. So let's keep the answers short. Brian asks, with 2016 StatsCan reporting 69% of Anglophones and 40% of Francophones possessing bilingual language skills, would this not suggest that there are two common languages in the province, the common French language of majority and the common English language of the majority?
From a sociolinguistic point of view, you could say that there are two common languages because each is spoken by historical communities within the province. So that's from a sociolinguistic perspective. But from a legal perspective, well, I think that Bill 101 and possibly what's coming up now, it would only consider French. Well, Bill 101 also says French is the only official language of Quebec, if I recall well. And also Bill 101 originally said French would be the common language of Quebec, spoken in public setting, language of work, possibly all types of institutional settings, like getting some sort of services from the government or from other public institutions. But Bill 101 originally, as crafted by Camille Lorrain, the common language did not include the freedom to choose the language that you want to speak at home, because that is a sacred setting where the state should not intervene. And assimilation to French by, let's say, Spanish or Anglophones use at home was excluded in Bill 101 from being, let's say, implicitly anyway, from being a badge of success or failure of Bill 101, because it said it's for the public official language that we are legislating. We are not intervening with the private language of citizens at home.
Very good. Chris Bourne's question. Are there Section 23 based arguments for overturning sections of what has been proposed in Bill 96? I think I'm going to direct that to Marion, and then maybe Agisha can go in, but please keep it short.
So Bill 96 surprisingly doesn't mandate a lot of new things for the English school system. It does curtail the temporary permit system, but that's for people who aren't rights holders, right? That's for people who are getting exceptions to the rule that only rights holders can attend school. So there's no direct infringement there of Section 23. However, Section 23 does take into account the vitality of the communities and the vitality of the institutions. And there's jurisprudence to say that, you know, if a policy restricts eligibility so much that, or a decision restricts eligibility so much that it curtails the vitality of the institutions and the communities, i.e. they can't find enough students, and they could if they could admit non-rights holders, then there is a Section 23 basis there. That's the Northwest Territories case that's coming up right now to the Supreme Court. So we'll see. They lost on the appeal, so this is kind of an open question of law, but that's where I'd place the Section 23 issue in Bill 96.
Great. We don't have a lot of time left, but Andrew Palucci, to everyone, says, as the government of Quebec looks to define our community as those who have the right to attend English schools, is it even possible to properly enumerate rights holders in Quebec? I'm not even sure that's not a rhetorical question, but maybe either just a minute from either one of you on that.
Marion?
Sure. I mean, I've heard mixed answers as to whether the government of Quebec has this information or not. The new census has some new questions that might make it possible to enumerate the rights holders in Quebec. I'm not a statistician, so I don't know to what extent it's actually going to work. But that would be an interesting source of data about Section 23 rights holders. But it still might not catch all of them. People move between provinces. People are educated in English outside of Quebec and then move to Quebec. I don't think the Quebec government is tracking them as adults. So it depends on what who you're trying to count. So that's all I know. I'm not a statistician.
Rishab, do you want to add to that?
Well, it's very difficult to implement because you would have to ask somebody who arrived, somebody who's in Quebec from the rest of Canada. Then you would have to find out whether that person took some schooling in a French setting or in the English, well, more in the English setting in Saskatchewan or in BC. These people would have to find out some documents to be able to prove that. And of course, those documents are usually required when you're trying to put your kid in, let's say, English school if you've come from the rest of Canada in Quebec. Now, parents will do that for their child because they want their child to go into the English school system. And they might be able to find the data that will testify that this child or that parent has been through most of its schooling in English outside of Quebec. But how can you do that for other reasons than for sending your kid to a school? If it's a question of getting a health service and you're sick, well, what's going to happen? How are you going to prove that your parents have been to mostly English school in Alberta and now you're allowed to be spoken to in English as you're suffering a very difficult illness? So all of that has a very technical and bureaucratic look to it, and it's not very human when people are getting really sick.
Thank you, Richard. So I've been told that that's pretty much it. I have to close off the question period. And Cindy just said, thank you both for your passion you have in these subjects. Yes, Cindy, and all of you, thank you for coming today. You can see that these two colleagues of mine keep me on my toes with what they're saying, and I appreciate their comments. To Marion's point when she started about Michael Rousseau, I invite you to see the QCGN statement that's coming out in both official languages very shortly. We are not letting anybody off the hook here. So thank you very much. It was great to see many of you that I haven't seen for a long time, and boy, do I want to hug you soon. Thank you. Take care. And if we don't fight, we kind of have to lie down. So let's keep on fighting. Thank you very much.
Okay.
Bye-bye.